Good morning, everyone. Good morning. How are we doing today?
Fine, thanks.
Morning, sir.
Oh, everybody managing okay? Planning for the national pause to handle it. Okay, so go ahead. Oh, sorry, I thought someone had come off mute. So I want to start today by having a quick chat just to check in and see what you learned last week and make sure that we're on the same page for anything that you may be confused about. So who wants to chime in with what they learned in last week's lectures? Don't everybody jump in at once.
Hi, Dr. Corral. I think I missed your question.
The question was, what did you learn last week in the lectures?
Okay.
Nothing?
Mainly mainly the elements of the tort of negligence. That was one of the primary things that I learned.
Okay.
You know, the elements of having a duty of care, that there must be a breach, you know, that there must be, you know, there must have been some damage caused, and as well that there needed to be some proximity. So that was one of the key things that I learned.
Okay. Is that it? Is that all we learned last week?
No, it isn't.
Okay. Then what else did we learn? Guys, this is to help you, right? If you're not getting the lectures, this is the point where you can chime in and say, hey, I'm not understanding this. Or you can, you know, if you just sit there like bumps on a log, I don't know how to help you. So Mark is right? But is that everything?
Additionally, I think we also looked at how the law around negligence would have developed from the Donahue Stevenson 1932 case, and you know that would have developed to the Anns, you know, to some changes that occurred in relation to Anns v. Merton, the Borough Council case, and now to what is the more current position in the Caparo case. Yeah.
And then the right, the Robinson case, the Poolborough Company, and then the Toombs case that we looked at on Wednesday of last week. Okay, so yeah, do you guys feel like you have a grip on this? Now, I want to be clear with you that I think that a lot of times undergraduates want certainty in, like, they want to be told this is the answer. And they want to have that so that they can learn that and sort of bring that into their minds. And one of the things that I think is really important in law, particular, is recognizing that there is almost never, right? There can be things that we use to figure out what the answer is, but it's almost impossible in law for there to be a right answer that we can just sort of write down and put in our brains and walk away from. So I want to just be clear about that you have to sort of embrace the uncertainty in law. Okay. So I think you guys you guys have correctly explained like what we were trying to cover last week. What questions do you have about it? Do you feel comfortable with it? Again, understanding that there's a lot of fuzziness surrounding this that you may still be coming to grips with.
I think for the most part, I'm taking the liberty to speak on behalf of the class. For the most part, I think we understand or have an idea of what we were taught last week, simply because we would have done some level of negligence in CRIM before. This is just more in-depth. So for us, some of the concepts we already know.
Okay.
But this is just, like I said, going more in depth into what we thought we knew. So it's a little more of a deeper understanding now.
Yeah.
Yeah, that's
is there anybody who wants to disagree with Keandre? You're welcome to do so. You're not going to hurt my feelings. You're not going to hurt his feelings. The point of this is to make sure that you're ready and have what you need to succeed in the class.
I agree with him, yes.
Okay.
I agree with him as well.
Okay. Okay. Great. All right. Well, again, if you don't, you're welcome to sing out. This is not, we're not closing the door on this and walking away. So you're welcome to email me or or get in touch with me some other way, or come to office hours, whatever works. And we'll make sure we get you on the right track. Okay. So this week's tutorial is reaching back 2 weeks to the first week's lecture, right, where we sort of did the 30,000 foot overview of tort law. And give me 1 second to pull it up. Okay. You were asked to prepare arguments for both for and against a proposition. And that proposition was that contract and criminal liability sufficiently deter negligent conduct without the need for independent causes of action in tort. So who feels comfortable offering up their argument for the proposition? Anybody?
Sir?
Yes, go ahead, Christiane.
Hi, good morning. Answering
morning.
that question for some reason, I don't know. I just could not get an answer, and I don't know if it was because they slew, but I just could not get an answer, and I
Well-
don't know why.
Well, let's. I doubt that it's that you're slow. You wouldn't be here if you weren't capable of doing this. But let's unpack it for a minute, right? Well, it looks like in the chat that some folks are better prepared for arguing against the proposition. Oh, here's someone who, Tyreek, why don't you offer us your argument for?
Morning, sir. Morning, everybody. So for so how I did it, I basically put out the aspects of contract and the aspects of criminal law that I felt would be deterring. So for criminal law, I have the punitive measures, which in itself would be deterring, sorry. And with contract, I have that it is deterring because most contractual agreements have mutual benefits for the parties. So why would you want to falter on those agreements? It's going to be detrimental to you. I also have the availability of defenses. So in contract law, from my research, there really aren't many defenses that you can rely on to escape a contractual agreement. As opposed to like a criminal law or a tort law, where you have a whole host of defenses, both mental and non-mental. So that's what I was able to come up with.
Okay, so for those of you who are like I only prepped one side. Now the prompt did ask you to prep for both sides. I recognize that one side may be easier than the other, and this isn't necessarily intended to be a balanced question, but it is intended to get you thinking in a way where you can argue both sides of a proposition, right? So, so I agree that the against is an easier argument. The status quo always has an easier argument, right? Which is part of why I want to hear your four arguments first. And I think Tyreek did a really great job of giving us some analysis for things that could take the place of tort liability through the contract and the criminal sphere. So what else do we have on the four side? Keandre, you said you did both.
Yeah, like I said earlier, we kind of did negligence in criminal law before. So I was saying, when you look at torts, there is the tort of negligence, but it is also covered in criminal law. So the argument that I was thinking for the question that we had is that if it is already covered in criminal law, then why is there a need for you to create an entire sphere just for something that is already accounted for? That was one of the arguments that I had for.
That's a great question. Let's hear from the against folks and hear what they say about that. So, Vincia, why do we need a separate tort sphere?
Because to me, like, for example, for contract, you'd have to have a contract for almost everything. If that was the case, for example, if I invite you to my home and I have a bad chair and I see you going to sit down in it and I don't tell you anything about it and you fall and you hurt yourself, but we don't have a contract between us, then I could just say, okay, well, sorry, my bad. But tort now, it creates some form of liability where you could receive damages from me.
Mm-hmm.
So,
do I have a duty to warn you that chair has rotted out and will collapse under you, right? Absolutely.
Yes.
You know, so I see you, Danielle. Let me hear from a couple of other folks, and then let me talk to you, Jewel. You said that you prepared to argue for the proposition. What did you have? Do you have anything? I say, do you have anything new to add to the conversation? That's not intended to suggest that you don't, just that you shouldn't feel the need to repeat points that others have made. Go ahead, Jewel. Your mic isn't working. That happens sometimes. If you want to use the chat while you're typing, we can go on to other folks. So Danielle, you can go ahead and make your point at this point. And I see your hand up, Karima.
Okay. Morning.
Good morning.
Just to expound a bit on what everybody else has said, the reason for, I would say, or rather against having, no, for having tort, yeah, the reason for having tort is because you have to look at the function of each area of law. So what is it that contract and criminal law are doing contrast to what the function of tort is? And the main focus we know for tort is to compensate the victim, whereas for criminal law, it is to punish the guilty. And contract law, the main function of that is just to ensure that the terms of the contract are met. And so in executing these functions, you have to also take into account the adequate remedies that each area provides. And so a remedy that I may need for any harm caused against me under tort might not necessarily be best covered under contract or criminal liability, because where I have suffered an injury because of someone's negligence, while under criminal law, that person may be prosecuted, I am not receiving the adequate compensation that I would need, where to say damages would have been best suffice. And then you could also argue that for contract law, you can receive damages in a way where you can have monetary compensation, but the main remedy for the court is to ensure that the terms of the contract have been carried out, and that would be your compensation. So even if you were so wronged in the contract where you would have suffered a great harm, if the terms of the contract can be met, then that harm isn't necessarily going to be corrected under those areas. And so you have to see where each area has an adequate function that is best carried out by being a singular party of law.
It seems, I mean, all of this seems right to me, right? I think that, certainly you're absolutely right that the purpose of contracts is to provide certainty in, transactions at the frontier of the firm. There's a little Coasian theory, firm theory for you. You are correct that, the purpose of tort law is to compensate the victim. And I think that I might rephrase the purpose of criminal law, but certainly there are people who would put it the way that you put it, right? A lot of people think that the purpose of criminal law is to punish the guilty. I would say that I would describe the purpose of the criminal law as falling more in the realm of vindicating the state's power, right? So, essentially crime is an act that it is unlawful for a non-state actor to perform. There's very little that's a crime that if the state does it, it's still a crime, right? So, but I don't disagree with I don't disagree that there are people out there who say that the purpose of criminal law is to punish the guilty. Okay. So Jewel, you stepped out and came back in. So do you want to take another stab at making your comment?
Hi.
Good morning. So lovely
Hi.
to hear your voice.
All right, I was saying that for like contract law, it has that you enter into a binding agreement between two parties, and if you breach it, then there will be penalties that the person that breached it will have to pay. And the same is in contract law because it's still between private persons because contract is civil rights. Sorry, tort is civil rights and contract is basically the same thing. It's just under a different name. So at the end of it, whether it may be contract, criminal, or tort, someone is going to be held liable for something that wasn't supposed to be done. That's what I was like.
And certainly, right, we can impose agreements on people by operation of law, right? The shrink wrap cases make that clear. And so we can actually go so far as to say, look, if you drive on the roads, you have reached an agreement with everyone else on the road that you will compensate them for harm, right? So we can actually conceptualize of the duty of care as an agreement, and that would create a contract liability rather than a tort liability. All right, Karima, you have been very patient. I appreciate it. You had your hand raised quite some time ago. Feel free to jump in and make your point now. And if you're, go ahead. Sorry.
Hi, morning.
Good morning.
Well, I just wanted to add to everything with saying that criminal liability, it have like a threshold that you have to meet, like a mark, and once the negligence doesn't meet that mark, then it won't be considered criminal, if that makes sense, right? Whereas in tort, there isn't that mark. Once there was a duty of care and damage was that duty of care was breached and damage occurred, then you could carry a case forward and it will get some sort of, your case will be heard. Versus in criminal liability, negligence has that there's a certain requirement that you have to meet, or a certain amount of.
What requirement are you thinking of?
I can't really remember it right now.
Don't feel bad. I'm not laughing at you. I am. If you knew the number of times that I have had to stand up in court and say, Your Honor, I know this is true, but I can't tell you how I know. So if you want an answer to your question, I'm going to have to go and brief it and get back to you. So it happens to the best of us, and also sometimes to me. So don't feel bad at all. All right. So Keandre, you had your hand raised, and then Tyreek.
Yes. So Karima actually made one of the points I wanted to make, which was that I asked a question earlier, why is there need for a separate sphere of tort? But one of the arguments that I had against was that whereas the negligence standard in crim is extremely high, it is not the same in tort. I think in crim you have to have like this extremely reckless type of high type of negligence for you to be considered negligent in crim, whereas for this it's a bit less. And I was saying one of the reasons why there is need for a separate sphere of tort is separate sphere of law, and we call it tort, is that in crim you can't punish, for lack of better words, a minor, but tort allows like it allows you the opportunity to punish somebody that we would consider a minor or underage, whereas criminal law you wouldn't be punished for negligence as a minor.
I mean, that's a policy choice, right? There's definitely jurisdictions where that's not true. So that where minors are held criminally liable for criminal negligence, right? so I think, I mean, I think that you're right that that's true in the Caribbean, but that's not like a statement of universal application, right? Tariq, go ahead. I'm sorry.
No problem, sir. So what I wanted to say is somewhat in addition to Keandre and Kareem, I think it was, but just to tie it together a bit more. So what I was looking at really is the burden of proof. So the burden of proof in criminal law is extremely high, beyond a reasonable doubt. And in that regard, it might not necessarily deter people from acting in a way that might be harmful to another. And not only that, but to get justice for the person harmed, it might be a bit more difficult in that sense too. So that's all I wanted to add. Um, the criminal law as not being deterring because of the high standard of proof as compared to tort.
That's absolutely right, right? So, if we assume that every case has some sort of provability, right? Whatever that means, however we measure it. And in a criminal prosecution, you can only obtain a conviction for cases whose provability meets this threshold, right? This very high, beyond a reasonable doubt threshold. Whereas you can get tort liability for cases where the provability only clears the balance of probability standard. Well, what that means is that conduct that falls between those two standards there will be no remedy for it, right? Because you would have been able to prove tort liability, but you can't prove criminal liability. So I think, Tyreek, that's a really important point. I really appreciate you bringing that to the table. So, Mark, your hand was up next. What was your thought?
Yes, I just wanted to add that if you start with the latter part of the question about the independent causes of action in tort or the need for it, those actions are brought by individual parties and not by the state.
Mm-hmm.
And the first part of the question is also suggesting that when it talks about sufficiently deterring negligent conduct, that there is a threshold of deterrence that may essentially result in no need for independent causes of action. So my thought on that is that there may be a degree of deterrence in terms of negligent conduct by criminal liability. However, causes of action in tort are brought by individuals or by private or private parties as opposed to the state. How do you reach a threshold where you would essentially would not have a need for individuals to bring actions when it would actually be their choice to bring those actions? So it is almost suggesting to me as if with contract and criminal liability, that you could reach this threshold where there's no need for civil actions, and I'm not sure how that would work. Where the state. Yeah.
I think that's a great point, right? Is that tort actions are brought by the wronged individual themselves, right? And that, I think, breeds a really important question of what happens to the wronged individual if the entity that can pursue action in these cases becomes the state. Yeah, and I think that's a really important question, and it raises some important policy implications related to shifting away from the status quo. So the more that you endow the state with the authority to control actions in tort, the more you take away the ability of wronged individuals to secure relief, right? And the more you leave people sort of out in the cold, having been wronged and without a remedy. So,
Can I ask a question?
Yeah. Go ahead.
Because, and the other point quickly, I don't want to cross Caleb's time, but the other point is that we learned about in criminal law about one of the purposes is to deter a certain type of conduct or conduct that is not that the state would like to generally not want. But is there really deterrence of negligent conduct? Because most negligence is not criminal. Most negligence tends to fall below that criminal threshold of gross negligence. And so I'm not sure if, whilst criminal law may deter the criminal aspect of negligence, does it also deter negligence in its civil form, so to speak?
Well, I think that yesterday's lecture, and I apologize again for the connection issues, but it's been recorded and it's up on YouTube. I think that yesterday's lecture may give you some insight into that, and that's not entirely fair, sort of tasking you with answering a question, drawing on the material from 2 weeks ago, and then telling you, well, I answered that yesterday. But it's true, right? I think that some of the things that the courts do in analyzing whether the duty of care has been breached give us some insight into what types of behavior would result from a deterrent effect of negligence, right? So if we're attempting to deter ordinary course negligence, the breach of duty analysis gives us some insight into what that would look like. So, all right, Caleb, you have been very patient. I appreciate it. Go ahead.
Okay, sir. I just wanted to add to Terry's point regarding the threshold for tort law. Basically saying for tort law, we only have to prove that we are 51% right. Well, in terms of criminal law, we have to prove beyond reasonable doubt. So we see that tort law has what you would consider as a lower threshold to be able to win.
And it's not even 51%, right? It's 50% plus anything additional, right? No matter how small, right? We don't even have to get all the way to 51%. We can get to 50.00001%, or add a whole bunch more zeros into after that decimal point, and you're still more likely than not, right? What I used to tell my clients is, we have to get the jury to the point where they're willing to flip a coin and bump it, right? So a true coin flip is 50-50. We want a little bit of a nudge beyond that. So, but that's a whole different issue. But I think you're absolutely right that the lower threshold for tort law leaves us with all these cases where we would find tort liability, but we can't prove criminal liability, right? And when we talked about this, maybe last week, maybe a couple of weeks ago, somebody mentioned the case involving O.J. Simpson, right, where the state of California was unable to convict him of murder, but the estates of his victims were able to hold him civilly responsible for their deaths, right? So, okay. Anybody else have anything they want to offer up? Go ahead, Mark.
Sorry, sir. I was going to ask you if you could define, I was just going to type it in the chat, but I'll ask it. Could you define what contract liability means in the context of the question? Is it limited to the performance that is due to the parties of a contract, or does it extend to something else?
Yeah, I think that's a really good question. Do we have to change the way that we conceive of contracts or crimes in order to be able to use those liability frameworks to encompass what we would normally think of as tort? And the answer to that is I think that it's okay to answer the question assuming that nothing changes, and to sort of go, okay, what can we do with the existing bodies of doctrine? But I think it's also okay to say, okay, if you want to do this, if you want to eliminate tort liability, you're going to have to change the rules for contract liability, and this is how I would change it. Right? So I mentioned imposing agreements on people by operation of law, right? You choose to do this, you choose to undertake some action, and that action manifests your agreement to something. You may look at that and go, that makes me really uncomfortable. Certainly it makes me a little uncomfortable, right? But that may be the necessary component, right? So I think the answer to your question is you can frame the question as you see fit, but you have to be explicit about how you're framing it. So you either have to say, okay, this is how I evaluate this given the current state of contract doctrine and criminal doctrine as I understand them. But in order to accomplish this purpose, these are the changes that I would need to see. So, okay. What other questions do you guys have? Can be about this week's, what we've done today, or anything else, whatever works for you guys. So. Nothing else? Okay. The contract liability. That is absolutely, Keandre says, with the contract liability as it is, couldn't one argue that the contract creates a relationship which would create a duty of care? And so where the obligation is not fulfilled, the court can order compensation. And the answer is absolutely, right? That would be how you would have to structure this, is you would have to create relationships to cover the kinds of circumstances that currently are covered in tort. So you're absolutely right. Okay. What other questions are there? So everybody feels good about today's conversation? You feel like you understood it? No, nothing confusing or unclear? So yeah, Danielle absolutely raises a good point that contracts limit themselves to their own terms. right? And so this was something that I think I mentioned in the first week of lectures, where you know, criminal liability and contract liability is similar, limits your financial exposure, right? Parliament defines that this is the fine, or this is the charge associated with this crime. Contracts usually, you know, limit themselves to some sort of compensatory value, whereas with torts, right, there are a lot of things that have to be taken into account in damages calculations. You know, there's non-economic damages. So there's any number of things. And Mark asks, do you always have a duty of care in all contracts? Is a duty to perform the same as a duty of care? And the answer to that is getting way out in the weeds of private law theory. And to be perfectly frank, I don't know the answer. You know, I think that there are some theorists who will tell you that they are the same in that they impose an obligation on you. And then there are going to be theorists who are going to say that they impose very different types of obligations, right? So I don't really have any better answer for you than, I think there are arguments on both sides of that question. Okay. So what else do you guys have? I don't have a problem with wrapping things up a little bit early if the lesson doesn't go the whole time, as long as you guys feel like you've gotten a grip on everything. So
can you, sir, elaborate a bit on, and it's not on the question, on the significance of Robinson in relation to how it would have changed the position in Caparo? If you can spend a couple of minutes on that.
Sure. And before I do that, I just want to note Danielle's comment in the chat that she says that the duty to perform is the same as the duty of care, because in exercising your performance, you have to take all adequate measures to fulfill the terms. And that's basically the argument on that side of the debate. The argument on the other side is that the duty of care is a broader duty than the duty to perform. The duty to perform is delineated. It is specific. This is the thing that you have to do. And you have to do everything that's required to perform, but you don't have to do anything that's not required to perform. Whereas with a duty of care, what's expected of you is very broad and amorphous and can be determined after the fact by the court. Okay. Talking about Robinson. Robinson is the case where I can't remember whether it was the House of Lords or the Court of Appeal, but it was one of the courts, but it may not have been the High Court, sorry. But they said, look, you know, the problem with Caparo is that lower courts are using it formulaically. And in Robinson, the court says, look, there is no formula for creating a duty of care. You have to start with the prior precedents. You have to say, okay, is there a case that imposed a duty of care in this fact situation? If the answer is yes, here endeth the inquiry, right? We have a prior precedent, we apply the prior precedent, we're done. If the answer is no, then we have to reason from the prior precedent via analogy. And we have to ask, is this case like the prior precedent where a duty of care has been imposed? And Only once we exhaust that, only then can we start to ask the question of whether there are any policy concerns that may animate whether a duty of care should be imposed, and can go in either direction, right? There are cases that say that policy requires that no duty of care be imposed because of the effects of that, and then there are cases that go the other way. So that's the difference between Robinson and Caparo, is that Robinson says, stop trying to find the set of boxes, the checklist that you can go down. Okay. This analysis doesn't work like that. This analysis is fact specific and depends upon how closely fit the case at bar is to prior precedents. And so this is why I tell you that there is no rule for the duty of care, right? The rule for whether a duty of care exists is, has one been imposed in the past, and does the judge want to impose one in this case? That's it. Okay, does that answer your question, Mark? Do you feel like you've got a better grip on Robinson now?
Yes, but are you?
Well, let me rephrase my question. Do you feel like Robinson? Do you feel like you better understand what the court was saying in Robinson, regardless of whether you feel like what they are saying is at all clear?
I get it that what I got from it, and maybe you can correct me if I'm wrong, I haven't gotten it all, is that so I understand what you explained. You shed some further light in that. Obviously, in Robinson, what they're saying is that let's just use these this three-pronged test as set out in Caparo, but let us first determine whether or not there is some precedence with respect to the facts that we have before us. What is a little fuzzy about that was that my understanding with Caparo was that I thought that Caparo related to addressing new cases of, or new factual situations,
right,
of duties of care that did not exist before.
No, you are correct. And that's where the analogical reasoning component of Robinson comes in, right? Because the Robinson court is saying, when you have these new situations where there's not prior precedent, you don't just sort of run straight to policymaking. You have to start with the prior precedent and reason by analogy from it.
Okay.
If this is completely unclear, that is because it is, right? This is, I will pull down and post an article that was written actually by my advisor that may give you a little bit of clarity. But basically, the lower courts were using the Caparo case as presenting a rule. And a rule is a term that we use to apply to mean that it basically, it gives you clear categories and you're either in or you're out. And the Robinson court is saying that actually this is a standard, and standards are significantly more fuzzy. They give courts a lot more discretion. They're harder to apply. Okay, so but I will post that article on e-learning. I can't imagine that a lot of you would be really interested in it in a lot of detail, but it may give you some clarity on what's happening between Caparo and Robinson. So, okay.
Okay,
we are
thank you.
we are out of time, and I have another tutorial in 10 minutes, so I can't let you guys run over. But I really appreciate everyone's engagement and participation, and I'll see you guys tomorrow. Don't hesitate to reach out if you have any questions. Okay, so take care and bye.